It introduces so many opportunities, so many unique business models.
People say blockchain could end companies as we know them.
For regulators,
Ripple, the creators of the cryptocurrency XRP, has been in a high-profile legal battle with the U.S. government since December 22, 2020. While the U.S. government going after businesses for shrinking the law is nothing new, it has to be noted that today's U.S. government is not the same as its predecessors. Over the last decade, trust in the government and its institutions has waned due to the public perception that it is being lied to. The government has been caught falsifying evidence in the past, and even though some may find it hard to believe the U.S. government would stoop to such lows, just to win a case, the plethora of documented incidents of this exact thing are hard to ignore. Let's take a look at Ripple XRP, their legal battles with Uncle Sam, and why their lawyers say SEC is delivering false evidence in XRP lawsuits. Before we get into this, take a few seconds to hit that like button, subscribe, and showing your support by ringing the notification bell. That way you never miss out on future updates. Ripple is a payment settlement system and currency exchange network that can process transactions around the world. The idea is that Ripple serves as a trusted agent between two parties in a transaction, as the network can quickly confirm that the exchange went through properly. Ripple can facilitate exchanges for a variety of fiat currencies, cryptocurrencies like Bitcoin, and even commodities like gold. Whenever users make a transaction using the network deducts a small amount of XRP, a cryptocurrency, as a fee. The transaction fee on Ripple is set at only 0.00001 XRP, which is peanuts compared to the gargantuan fees charged by banks for international payments. As of late April 2021, the XRP price was $1.38 per token, meaning the transaction fee works out to be just $0.0000138. XRP is a cryptocurrency that runs on XRP Ledger, a blockchain designed by Jed McCaleb, Arthur Brito, and David Schwartz. McCaleb and Brito would go on to find Ripple and use XRP to facilitate transactions on the network. You could buy XRP as an investment, as a coin to exchange for other cryptocurrencies, or as a way to finance transactions across the Ripple network. Notably, XRP's blockchain operates a bit differently than most other cryptos. Other cryptocurrencies open their transaction ledgers and verification process to anyone who could solve complex equations quickly. But transactions are secure as the majority of ledger holders must agree with the verification for them to be added. Instead, the XRP's Ripple network somewhat centralizes things. While anyone can download its validation software, it maintains what it calls unique node lists that users can select to verify their transactions based on which participants they think are least likely to defraud them. Its default list currently contains 35 trusted validators. Ripple decides which validators to approve for this list and also makes up 6 of these validation nodes. However, users can opt out of this default list and hypothetically remove Ripple-backed validators from their transactions entirely, instead of constructing their lists of trusted validators. This would allow the network to continue to approve transactions even without Ripple the company remaining involved, or even continue to exist. As new transactions come in, the validators update their ledgers every 3 to 5 seconds and make sure they match the other ledgers. If there's a mismatch, they stop to figure out what went wrong. This allows Ripple to securely and efficiently validate transactions, which gives it an edge over other cryptocurrencies, like Bitcoin. 3 days before Christmas in 2020, the SEC formally charged Ripple and 2 executives with conducting a $1.3 billion unregistered securities offering. The trouble for Ripple started back in 2012, when an international law firm wrote 2 memos for the blockchain company, Ripple Labs, as Ripple and its top executives contemplated the launch of XRP, a new cryptocurrency designed to compete with Bitcoin. Ripple wanted to know, among other things, whether and under what circumstances XRP could be considered as an investment contract, subject to federal security laws. The law firm, whose identity is not publicly known, analyzed that regulatory risk in memos provided to Ripple in February and October. Those memos are now a matter of dispute between Ripple and the Securities and Exchange Commission, which sued the blockchain company in December for allegedly conducting an unregistered offering of $1.3 billion in XRP between 2013 and 2020. Among the SEC's allegations, Ripple's lawyers told the company in those 2012 memos to ask the SEC how to distribute XRP without triggering security laws, but the company ignored its lawyers' advice. Ripple, of course, has quite a different take on the 2012 memos, arguing last month in its answer to the SEC complaint that the government had mischaracterized the legal advice in the documents. According to Ripple, any reasonable reader of the memos would conclude that the company's lawyers did not believe its digital tokens were security under federal law. The case is now 6 months in, and Ripple seems to be slowly edging closer to a big win against big government. Presiding over the case is Magistrate Judge Sarah Netburn, whose discovery hearing in U.S. District Court for the Southern District of New York on April 6 of this year exposed the SEC's unfounded and flawed arguments and some inconvenient truths for former SEC Chair Jay Clayton and former SEC Corporation Finance Division Head William Hinman. The hearing showed that the case against the San Francisco fintech startup was based on an illogical premise. It alleged that XRP, the digital currency that Ripple uses for cross-border payments, has been unregistered security since 2013, and that the SEC was just getting around to saying so on the last day of Clayton's tenure last December. With this late-in-the-game regulatory determination, the SEC now deems that every Ripple sale for 7 years was an illegal securities trade, and that Ripple, its 2 top executives named in the suit, along with millions of retail holders, should have known this all along, even though the agency never did. Due process and fair notice were thrown out the window to get the case across the transom on the day that Clayton walked out the door. The hearing detailed the many vague, contradictory statements regulators made on cryptocurrency over the years. In 2018, Clayton told CNBC that Bitcoin is not a security, and Hinman gave a widely covered speech which laid out how Ether was not a security, despite debuting an initial coin offering, ICO, in 2014. With XRP, they said its status had not been determined. Trading platforms asked the SEC if XRP was a security before listing the token, and the agency refused to clarify. When asked whether XRP was a security, the then chairman of the Commodity Futures Trading Commission, Heath Tarbert, in a 2020 interview declared, quote, "It's unclear. Stay tuned. We're working closely with the SEC to figure out what falls into what box." End quote. If these regulators were honest, they would admit that nothing in the 1933 Securities Act refers to cryptocurrency, and then would request Congress to clarify the statute. Instead, the SEC made an unfounded determination with no warning or process. During the hearing, Ripple requested the internal documentation to explain how and why the SEC arrived at their pronouncements, as well as silence on these various coins. The SEC responded that nothing said by Clayton, Hinman, or any SEC official about Bitcoin or Ether was an official determination, or whether they are securities. It appears that Netburn is not buying the SEC's argument that their many statements were not material. In a March 22 hearing, she told the SEC her understanding of XRP. Quote, "Not only does it have a currency value, but it has a utility, and that utility distinguishes it from Bitcoin and Ether." End quote. This rejects the SEC's story that XRP has never had utility. Netburn ordered the SEC to provide all communications related to XRP, Bitcoin, and Ether where a third party was involved, and any formal internal documents expressing the agency's interpretation or views on cryptocurrency, and to deliver them to Ripple. She granted most of Ripple's motions, which means that the discovery could be a treasure trove of embarrassing information for the SEC. This could mean game over for the SEC's case against Ripple, and more largely, a serious blow to the agency's credibility. Other defendants will cite the SEC's arbitrary and capricious nature. These disclosures could bring a new headache to scandal-plagued Apollo Capital Management, which Clayton joined upon leaving the SEC, ostensibly to clean up the mess left by founder Leon Black and his links to Jeffrey Epstein. The timing of the lawsuit on Clayton's last day and his subsequent hiring by a crypto-focused hedge fund are very curious coincidences. Conflict of interest concerns could also intensify for Hinman, now back at his old firm, Simpson Thacher, which paid him a $1.6 million annual pension while he worked at the SEC. Hinman's influence to the determination that Ether is not a security keeps the SEC regulatory paws off Ethereum, the blockchain platform which Simpson Thacher supports as a member of the Ethereum Enterprise Alliance. Simpson Thacher also handled a $1 million IPO of Canaan, the Chinese maker of machines used to mine cryptocurrency. Netburn's order should bring much-needed transparency to the case. With that said, thanks for watching. Be sure to leave your thoughts in the comment section below. And thumbs up if you enjoyed the video, subscribe, and ring the notification bell to stay updated. Until next time.